So I'm talking about feminist activism against gender ideology in the UK, and I'm particularly going to focus on activism against recent attempts to introduce self-declaration of gender identity in law, and also activism against the self-declaration in practice, which has already happened in the UK in many public sector organisations and private sector ones without any changes in the law, which is what's happened in most of the countries as well. Because this is an international webinar, I'm aiming to give an overview of what's happening in the UK to women from other countries. So women in the UK who are active in this area, a lot of what I'm saying will be familiar to you. And I'm going to focus on grassroots feminism rather than feminist academic work or journalism, not because I don't think they're important, I think they are, and a number of feminist academics and journalists have made important contributions to the struggle against gender identity ideology. But my focus is activism. In both England and Wales and in Scotland, proposals for self-declaration of gender identity have been made in recent years by both governments. There are separate governments in England and Wales on the one hand, or Wales also has a separate government to some extent as well, and in Scotland and also Northern Ireland. These proposals have been publicly consulted on, and this has created opportunities for feminists to challenge self-declaration in ways which haven't been possible in some of the countries which Eugenia referred to. It was introduced in many countries without consultation, often by stealth, without the public even knowing it was happening, let alone being consulted about it. And that has not happened here. There wasn't widespread publicity about the consultations in either England and Wales or Scotland, but at least there were consultations and feminists were able to challenge self-declaration because of that. Now, although self-declaration hasn't been introduced in law, at this point anyway, in the UK, de facto self-declaration or self-declaration in practice has been introduced, as I've said, by stealth, by a process of policy capture by organisations promoting gender ideology. And that de facto self-declaration is becoming more and more of a focus now in the UK for feminists. So I'm going to talk about feminist campaigning against the proposed changes in legislation first, and then talk about the current campaigns and activism which is taking place in regard to the self-declaration in practice. I'll say a little bit about the law here first. The UK has 3 jurisdictions: England and Wales, Scotland and Northern Ireland. And some powers are devolved from the UK government based in Westminster to Scotland, to Northern Ireland and to a lesser extent to Wales. The current law relating to gender identity is contained in the Gender Recognition Act, as I'm sure most people here know. It applies in all 3 of the jurisdictions. But Scotland and Northern Ireland can amend it independently from the Westminster government if they choose to do so. In its current form, the Gender Recognition Act requires somebody applying to change their legal gender to be supported by a diagnosis of gender dysphoria, which is supported by one medical practitioner and a psychologist who's an expert in that area, and another medical practitioner. It also requires the applicant to have lived in the acquired gender that they wish to acquire for a period of at least 2 years before the application, and the application is reviewed by a gender recognition panel. If the applicant succeeds in being granted a change of legal gender, they're given a gender recognition certificate, which allows them to change their documents to their so-called acquired gender. At the moment, women's sex-based rights in the UK are protected from some of the potential negative effects for women and children of the GRA by the Equality Act 2010. That's designed to protect people from discrimination and their sex, gender reassignment, age, disability, marriage and civil partnership, race, religion or belief, and sexual orientation. The Equality Act doesn't apply in Northern Ireland, only in England and Wales and in Scotland. Unlike the GRA, the power to amend the Equality Act is reserved to the Westminster Parliament. The other governments can't amend it. The Equality Act allows single-sex services and spaces to be maintained, and it makes a distinction between sex and gender reassignment. And that single-sex provisions for women, which excludes males who say they identify as women, is included in that. And that is also the case where they have a gender recognition certificate. So I'm going to read out a quote from the explanatory notes, which are designed to help people to interpret the legislation. And it says, a group counselling session is provided for female victims of sexual assault. We're just giving one example here. The organisers do not allow transsexual people to attend, as they judge that the clients who attend the group session are unlikely to do so if a male to female transsexual person was also there. This would be lawful. And it is lawful, but gender lobby groups have spent the last several years telling all sorts of organisations in the public sector and the private sector that it isn't lawful, and that males who identify as what they call trans women should be allowed access to all single-sex spaces. That is not the case, but it's what many people believe because of the lobbying that they've undertaken. Feminists have used the exceptions in the Equality Act to hold women-only meetings in the past, and still could in the future. For example, the Campaign to End Rape organised a conference on sexual violence in London, in the London Borough of Camden in 2015. And they used the exceptions to argue to the legal department of the local authority that they should be able to exclude males who identify as trans women, because otherwise survivors of sexual violence would not feel comfortable attending the conference. And the legal department accepted their arguments, and not only that, but the local authority provided security at the conference to make sure it was women only. I'm not sure whether that would happen today, but that was what happened in that instance. And many sexual and domestic violence services in the UK do use the exceptions in the Equality Act to maintain single-sex services. Some don't, because they're unclear about the law and they're scared of legal challenges. Some don't because their funding might be threatened if they exclude trans-identifying males. And there are some services who have accepted the argument that trans women are women and include them in domestic violence services. In some cases, not just as women, as people using the services, but as workers in the service as well. That's not common, but it has happened. During the last 4 years, reforms to the GRA, which would introduce self-declaration, were first of all introduced or proposed in England and Wales and then in Scotland. In 2016, the House of Commons Women and Equalities Committee report on transgender equality recommended reform of the GRA to introduce self-declaration for anyone over 16 who could change their legal gender simply by means of completing a statutory declaration. A statutory declaration is just a form that has to be signed in the presence of a public notary. A public notary would include a solicitor, for example, and that's all they do. You bring the form to a solicitor or other notary, you sign it in front of them, and the statutory declaration is complete. And that's all that would be required. The committee also recommended that the Equality Act should be amended to prevent trans-identified males with a gender recognition certificate from being excluded from single-sex services and spaces. Later on, when they were questioned about this, they denied that they'd recommended that effectively, and many of the gender lobby groups who argued for that in the course of the consultation also denied that that's what they were lobbying for. But it's very clear in the report of the committee that that is what they were lobbying for, and that the committee accepted that as a proposal. The consultation in England and Wales ran from July to October 2018. In Scotland, the Scottish Government have had 2 consultations. The first one was from November 2017 to March 2018. It was criticised because of its lack of transparency, because it was not widely publicised. Eventually, those reform proposals were put on hold because of the criticisms, at least in part. And then in December 2019, the Scottish Government announced the launch of a new consultation based on a draft bill. The draft bill proposals were very similar to the Women and Equalities Committee proposals. Legal gender could be changed at the age of 16 upwards by means of a statutory declaration. It did add a requirement that the person applying had to have lived in the gender they wanted to acquire for the 6 months leading up to the application. Doesn't explain what that means, or neither does the GRA. And once the application is accepted by the registrar of births and deaths, the applicant would have to wait for another 3-month period and then confirm that they wanted to go ahead, and also confirm that they intended to live in the new acquired gender for life. These 2 sets of proposals set in motion an explosion of feminist activism in both England and Wales and in Scotland against self-declaration. There was activism in the UK in relation to gender ideology before that. In 2014, for example, a group of women picketed a so-called Dyke March, where the main speaker was a trans-identified male who called himself a lesbian. Transgender Trend, which campaigns against the transing of children, was established by Stephanie Davis-Arra in 2015. In 2016, Julia Long organised a conference in London called Thinking Differently, Feminists Questioning Gender Politics. The Lesbian Rights Alliance, which campaigns around the effect on lesbians of gender identity ideology, was set up in the same year. Those are just some examples, and there are probably a lot more. I wouldn't know that much about them because I didn't become involved in activism around this issue until the proposals for self-declaration were introduced. Before that, I was very focused on working on other aspects of sexual violence, and it wasn't until that point when I started looking more closely into what was happening that I realised what a threat to women's sex-based rights gender ideology is. Several radical feminists and both individuals and groups responded to the committee's consultation, but they were ignored. After the consultation, grassroots feminism against it started to develop, and a lot of the organising focused on what I would essentially say were three strategies. Firstly, developing links between women in order to build a strong resistance to the self-declaration proposals. Women were in contact through, in real life, face-to-face, through Facebook groups, often private Facebook groups on social media, and there was an explosion of different social media connections between women around that time. Secondly, informing the public about the self-declaration proposals and their implications for the rights of women and children. Most of the public still don't know about self-declaration and what it will involve if it's introduced. And thirdly, influencing government and other public bodies. For example, women lobbied their MPs. There were meetings in Parliament, both in Scotland and in England, and in both parliaments. And women have lobbied other public bodies like sporting bodies. They've been campaigning around the placement of trans-identified males in women's prisons and a range of other areas where different organisations have been lobbied about this. Can I have the first slide, please? It's the second slide on the PowerPoints.
Joe, are you able to do that?
Okay, can you put it on the second one? Oh, okay, thank you very much. These are the logos of the main groups involved in challenging gender ideology, particularly since the self-declaration proposals were made, but many of these groups existed before that. I've already mentioned Transgender Trend and Lesbian Rights Alliance. I'm not going to go through each of them individually, but I'll be talking about the various groups as I go along. I just thought that showing you the logos all together would give you a sense of what's been happening and how much has been happening in response to the self-declaration proposals. In England, the groups involved included We Need to Talk, Woman's Place UK and Let a Woman Speak, who all organised public meetings in different parts of the country. Some also organised meetings in England, in Wales and Scotland. Some groups focus more on direct action and local campaigns. For example, there's a network of feminist groups working around challenging gender ideology called Resisters United, which have groups all over the country. They are involved in local campaigns, but they also organise local meetings sometimes. Posy Parker of Standing for Women had the idea of using the dictionary definition of woman, adult human female in the campaigns, and that really took off. I think it was a brilliant idea and galvanised a lot of women around what was the core of this, that we want to retain our definition of women as being an adult human female, and that should be based on biology and not notions about gender identity. Standing for Women printed the definition on stickers, t-shirts and a range of other goods, and they also projected it onto public buildings during, for example, political party conferences. And in one evening in January 2019, resistors groups in different parts of the country dressed local statues in the t-shirts, and that generated a lot of publicity in local media. It was also important in creating solidarity between women and women inspiring each other. Another group, Fair Play for Women, focuses on raising public awareness, carrying out research and analysis and influencing policymakers. I've already mentioned that they are particularly working around sports and trans-identified males in prisons. And during the consultation, Fair Play for Women and A Woman's Place UK, which has probably organised more meetings around the country than any of the other groups, included guidance on completing the consultation on their websites. Stonewall, the leading gender ideology lobby group in the UK, did the same, but obviously from a different perspective. In the run-up to the consultation closing date, Fair Play for Women organised public leafleting about the self-ID proposals. I was involved in the leafleting. I leafleted in 2 areas of North London, and the vast majority of people we spoke to were unaware of the proposals until we spoke to them, and they were shocked by them. Most of them didn't agree with them. Many of them said that they would complete the consultation. And as part of their strategy for informing the public, Fair Play for Women also took out an ad, a full-page ad in the Metro, which is a new free newspaper which is provided at public transport hubs all over the country. It's very widely read. I worked out that between September 2017 and March this year, there were at least 47 public meetings organised by feminists challenging gender identity ideology. And there may well have been more that I don't know about. Particularly in the earlier stages of feminist campaigning, gender ideology activists tried to get the meetings shut down. They phoned venues and tried to get them to cancel. They said that the women were hate groups. They demonstrated outside meetings. Often they harassed women who were going in. And in September 2017, Maria McLachlan, while she was waiting to attend a meeting in London, was physically assaulted by activists, one of whom was convicted of assault by beating in relation to that assault the following year. His name is Tara Wolfe. He calls himself a trans woman. The attempts to silence women and to stop us assembling made many women more determined to be involved in the campaign, I think, and many women were radicalised when they saw what was happening. They realised the seriousness of it, I think. Sometimes for the first time. Sympathetic journalists in national print media wrote about the harassment and threats that women were receiving, and so the public became aware of that and more aware of the self-declaration proposals because of that. As time went on, the harassment decreased. It started up again sporadically, but on the whole it decreased, I think, because some activists at least realised that from their point of view it was counterproductive. They were actually, in many ways, because of the publicity it was generating, they were helping us and not helping their own cause. There were also meetings hosted in the House of Lords by sympathetic peers, members of the House of Lords, and several meetings were held by members of the Scottish Parliament in Edinburgh in relation to the Scottish proposals. I think that feminist campaigns have had an effect, certainly in England. It's not so clear in Scotland yet. In April, the new Women and Equalities Minister, Liz Truss, spoke about her intentions in relation to GRA reform. She said it will be reformed later this year, but she said there were 3 very important principles underlying the reforms, the first of which she mentioned was the protection of single-sex spaces. Secondly, making sure that transgender adults are free to live their lives without fear of persecution. But she went on to say, whilst maintaining proper checks and balances. That suggests that self-declaration will not be introduced because there are no checks and balances in self-declaration. And thirdly, making sure that under 18s are protected from making irreversible decisions which they may regret later in their life. In Scotland, the groups For Women Scotland, Women Make Glasgow and LGB Alliance campaigned against the self-declaration proposals. LGB Alliance are, as the name suggests, an LGBT organisation, but they're led by lesbians and they work very much from a feminist perspective. They have been in place for about 6 months now. But have the screen back, so I need the next one shortly, if that's possible, please. And they were very involved in the Scottish campaign because that happened shortly after they started. For Women Scot raised £14,730 for their campaign in a period of 28 days, which was pretty good going. They held public meetings in Edinburgh. And they also attended meetings at Holyrood, which were organised by MSPs. Unlike MPs in England, who define themselves as feminists, who are in left-wing parties, left-wing MSPs have spoken out against gender ideology. A number of them have, and in January this year, Johann Lamont, a Scottish Labour MSP, and Joan McAlpine, a member of the Scottish National Party, all hosted a meeting called Women's Sex-Based Rights, Considerations for Policy Making and for Legislation. That was in the Scottish Parliament. It was attended by at least 13 other MSPs and representatives of voluntary sector and public sector groups. Rona Hodgkiss, a former prison governor, spoke about the impact on women in prison of trans-identified males being placed in women's prisons. And the next day, one of the MSPs who'd attended raised that issue in the Scottish Parliament. So those meetings did have effect, they had ripples out into the larger group of MSPs. As with Fair Play for Women, Forum in Scotland produced a guide to help people to complete the consultation, and they held public meetings, 2 of them, to help people do that as well. They launched a Bin the Bill campaign in February, and they also organised leafleting around the country. And on their website, they've commented on this and have said the following: the response we received confirmed what we all know. The vast majority of the public share our concerns, think self-ID of sex is ludicrous, and do not wish to see the DRA reformed in this way. And that was my experience in London as well. In the final days of the run-up to the end of the consultation period, For Women Scotland, Women Make Glasgow and the LGB Alliance took out full-page ads in national Scottish newspapers, informing people about the self-declaration proposals and the risks to women. In early April, the Scottish Government announced that work on the GRA was going to be suspended, at least for the moment, because they needed to focus on the COVID-19 pandemic. It's not clear what will happen in the future, but it looks unlikely that it will be brought back in the new session of Parliament, which is in September. Can I have the second slide? I might be able to do it here. No, I can't. Okay. So I just wanted to mention briefly before I talk about the campaigns against de facto self-declaration, and this is linked to that really. There's recently been a cross-party group of women who've come together to protect sex-based rights. There are women from all the major political parties, the Conservative Party, Labour Party, the Green Party, the Lib Dems, the Women's Equality Party, and the Scottish National Party involved in it. Women's Human Rights Campaign is also involved in it. I didn't include Women's Human Rights Campaign on the previous slide because we're an international group, or internationally focused, and our main focus is not in the UK, although we do lobby and get involved in campaigns in the UK. We're involved in Women Uniting, as is Filia, which organises a national conference, feminist conference every year. The group here recently wrote to Liz Truss in response to her comments, urging her to protect sex-based rights in the future when any GRA reforms are introduced. And I think this cross-party, essentially coalition of women, is likely to be very effective, particularly as there's a Conservative government in power at the moment in England, and Conservative women have joined it. Okay, thanks. I don't need the slides now. Thank you. So for the time being, self-declaration of gender identity in law isn't going to happen, but it could happen in the future. But even if it isn't introduced in the future, we have a huge struggle to challenge the self-declaration in practice, which has already happened right across the public sector. Criminal justice agencies such as the police service, the prison service, the courts, all of them have introduced self-declaration in practice. This has happened without any public consultation and seems to be the result of policy capture by gender lobby groups, some of whom are very influential, particularly organisations like Stonewall, and there's another very busy lobby group, Gendered Intelligence, which has been involved in producing guidance for schools and a whole range of other guidance. I'll just give a definition of policy capture from the OECD, the Organisation for Economic Cooperation and Development. They define it as the process of consistently or repeatedly directing public policy decisions away from the public interest towards the interest of a specific interest group or person. Capture is the opposite of inclusive and fair policy making and always undermines core democratic values. The capture of public decisions can be achieved through a wide variety of illegal instruments such as bribery, but also through legal channels such as lobbying and financial support to political parties and political campaigns. Undue influence can be exercised without the direct involvement of public decision makers. As in many of the organisations which have adopted self-declaration at the moment, by manipulating the information provided to them or establishing close social and emotional ties with them. One of the ways in which gender lobby groups have influenced policy in practice is by training and consultancy. Many organisations see them as experts. They go into those organisations to provide training and consultancy, and in doing that, they misrepresent the Equality Act and they lead people to believe that have led an awful lot of organisations to believe that it's unlawful to exclude trans-identified males from female single-sex spaces. It's not, but they've been very successful in promoting that idea. De facto self-declaration is leading increasingly to the presence of biological males in female single-sex spaces such as refuges, hospital wards and prisons, and changing rooms in public sports facilities. Crimes committed by men are being recorded as having been committed by women, and they're in both by criminal justice agencies and by the media. Trans-identified sex offenders have been placed in women's prisons in recent years, including many who don't have a gender recognition certificate and are therefore male in law as well as in reality. One example is Karen White, who was convicted of sexually assaulting 2 women while he was on remand in Newhall Prison. He was convicted in 2018. He was on remand for sexual offences, including rape, and he was later convicted of rape, and he was placed in a women's prison. At Tara Wolf's trial for assaulting Maria McLaughlin, the judge told Maria to call him she while she was giving her evidence. And she tried to do this, but she kept reverting back to he, because if you're in a witness box, you're very nervous. And the judge made negative comments about this in his summing up. People have been sacked from their jobs for saying that men can't literally become women. Feminist organisations are now challenging this policy capture, and they're focusing, I think, at least at the moment, on 3 main areas, or a lot of the challenges relate to 3 main areas, and they are the transing of children and child safeguarding issues that occur when boys who identify as trans girls are allowed access to girls' single-sex spaces in schools and other institutions. Safe Schools Alliance and Transgender Trend do a lot of work around that. And the placement of trans-identified males in prisons and trans-identified males in women's sport. Fair Play for Women in particular is doing a lot of work around that. And they've managed to involve very well-known sports people in their campaigns. As well as being crucially important to the challenge to gender identity ideology in and of themselves, these 3 areas are areas where it's relatively easy to gain public support, because most people agree with us about them, I think. They see the risk to girls of school policies allowing boys to use girls' bathrooms and sleep in the same room as girls on residential trips. They see the risks to women of being forced to play in sport against men, especially contact sport, and they see the risk to women of being imprisoned with males. And most people immediately see the unfairness of males being involved and competing with women in sport. There have been a number of legal challenges to local education authorities who've used toolkits, all of them produced under the guidance of trans lobby groups or pro-trans lobby groups. Their policies usually say that trans-identified students should be able to use the toilets and the changing rooms of their choice. They should be able to use the sleeping facilities of their choice on school trips. And if, for example, girls object to that, those girls are deemed to be transphobic, and the guidance is they should be placed within a different changing room or a different toilet or a different sleeping facility. They should have to move over to accommodate boys who see themselves as trans girls. In Warwickshire, parents recently challenged the local authority's trans toolkit. Warwickshire is a local authority, has each area in England has a local authority where the local government is in control of education. The parents challenged the trans toolkit there. They said it breached equality law and it breached basic child safeguarding principles, and this resulted in the local authority agreeing to withdraw it and review it. Very similar guidance was used by Oxfordshire County Council. This guidance was challenged in the courts by a 13-year-old girl who was supported by Safe Schools Alliance. In April, a High Court judge decided that the guidance could go to judicial review on the basis that it's sufficiently arguable that it's unlawful. A judicial review is a legal proceedings which looks at whether a public body, like a local authority, police service, a whole range of other public bodies have acted unlawfully. Initially, Oxfordshire said that they were confident that their guidance would be found to be lawful. However, yesterday, they announced that they were withdrawing the guidance for review, and they were also withdrawing from the judicial review. So they're not using the guidance anymore, so there's no substance to the judicial review anymore. Safe Schools Alliance and an organisation called We Are Fair Cop, who have campaigned around freedom of speech in relation to gender ideology, have also supported a 14-year-old girl who challenged guidance published by the Crown Prosecution Service. It was produced with a great deal of input by gender ideology lobby groups, and essentially says the girls who object to trans-identified males in their private spaces are involved in transphobic bullying potentially, and that can constitute harassment. After receiving a pre-action letter from the solicitors acting for the girl, which threatened a judicial review if the guidance wasn't withdrawn, the Crown Prosecution Service withdrew it immediately. And they said that they're going to review it. A judicial review is also being brought against the Tavistock and Portman NHS Trust, which is the leading gender identity clinic for children in the UK. The judicial review is challenging the use of puberty blockers with children, and it's being led by a young woman called Kira Bell, who's a detransitioner. A senior High Court judge found that it's plainly arguable that the Tavistock practice of giving puberty blockers to young children is unlawful, and there's likely to be a full hearing in the High Court of the case before the end of July. That might be delayed because of the virus, I don't know, but there is going to be a full hearing. There's also a judicial review of the prison service policy of housing trans-identified males in prisons. It started last October. I'm not quite sure where it is at the moment, but it's being brought by a woman prisoner, and she's arguing that the placing of trans-identified males who've committed sexual and violent offences against women, placing them in women's prisons is unlawful, and she's also challenging the prison services practice in relation to what's supposed to be a separate unit for trans-identified males in a women's prison in Surrey, in Downview, but this separate facility isn't really separate because the trans-identified males mix with women in education courses, in the prison gym, in other places around the prison. So she's challenging that and saying this separate facility is not a separate facility, and women are being put at risk because of it. A case in which feminist arguments were not accepted is Mayor Forstata's employment case. Last year, Mayor Forstata was effectively fired from her job as a researcher with a policy think tank because she stated on Twitter that men cannot literally become women, and expressed concerns about the Women and Equality Committee's self-declaration proposals. She brought employment tribunal proceedings and argued that her belief that people cannot literally change sex should be seen as a protected philosophical belief. The judge rejected that argument and went as far as to say that this belief, in its absolute form, is not worthy of respect in a democratic society. He seemed to be suggesting that if it was less absolute, it might be. So if she was saying, well, some men can change and become women, but this other group of men can't, so that wouldn't be absolute, then he might not have taken the same view. I'm not sure. But anyway, he said that she was absolutist in her view. He criticised the fact that she called a man who described himself as non-binary he. That was a terrible transgression, I think, in the eyes of the judge. And she lost the case. Now, the case may go to appeal, and I hope it will, because I think it will have a good chance of success there. But the reasoning of the judge is very concerning, because it makes it very difficult to freely express disagreement with gender ideology arguments about whether people can or cannot change sex. And it's very difficult to argue for sex-based rights if you can't do that. I'm going to finish by talking about an important recent decision which upholds the biological definition of mother in law, which I think is an important case. It was brought by Freddie McConnell, who identifies as a trans man and has a gender recognition certificate. McConnell has a young son who is called YY in the proceedings, who was born after the gender recognition certificate was granted. McConnell wants to be registered as the child's father on the child's birth certificate, or alternatively, to be registered as a parent or as a gestational parent. That has echoes of the language used in surrogacy. This was refused by the Registrar of Births and Deaths. McConnell took the case eventually to the Court of Appeal because the lower courts agreed with the Registrar, and the Court of Appeal rejected the appeal as well. The case hinged largely on Section 12 of the GRA, which effectively states that when somebody obtains an acquired gender through the GRA, their status as the mother or father of a child does not change. McConnell argued that that provision only applied to people who had obtained gender recognition certificates after a child was born, and that it wasn't intended to apply to people who gave birth to a child or had a child in some way after they'd obtained a gender recognition certificate. But the judges rejected that argument. They also rejected the argument that the current law is a breach of the Article 8 right to respect for private and family life of Freddie McConnell and the child, YY. They said the law pursues a legitimate aim and it does so in a proportionate way, therefore it doesn't breach Article 8. And I think it was significant in that case that the court emphasised the importance of making their decision at a general level and not at the level of the facts of an individual case. They stated, the question is not whether it would be in the best interests of YY to have the person who gave birth to him described as his mother on the birth certificate. The question is whether the rights of children generally include the rights to know who gave birth to them and what that person's status was. Now, gender ideology is rooted in an extreme form of individualism, which bases its arguments entirely on individual subjective feelings and perceptions, and not on material reality, and it demands that the rest of society adopts in order to accommodate those subjective feelings and perceptions. The fact that the court emphasised the broader social effects of any decision they made over individual feelings and individual circumstances, I think is potentially significant for the protection of the sex-based rights in other contexts, or at least I hope it will be. But for now, at least, the decision protects the sex-based rights of women in their role as mothers and also protects the rights of children to know who gave birth to them.